So on the defendant's motion to compel plaintiff to produce these documents, that's going to be denied. The motion to determine the confidentiality of the motion is also denied, meaning it's unredacted. If the motion itself is unredacted, the exhibits themselves are continue to be confidential.
Your Honor, with that, can I just move to unseal the bench discussions that we had a couple moments ago when I was arguing the motion and Mr. Rowe came up and then the subsequent colloquy that we had just now?
Yes. From the court reports.
Right. How far back would we go?
It was just the two of them.
Okay.
But bench conferences, and one of them pertained, because I asked about the name that you were referring to, and I didn't think I had sealed that. So you told me that name. And then talking about the...
I thought there were 3 bench conferences.
Okay.
And I know that I think some of the first one, maybe part of the second one, are issues that have not been disclosed. But they need to stay.
I try to pretty much mirror what was in our papers. There may be, with one exception, I discussed specific provisions of the settlement agreement between Mr. Belay and Mr. Clem that I don't think are in our papers.
And I know that you mentioned names that you said you were not redacting. I mean, that you were keeping redacted certain names.
Not keeping redacted. Oh, that's right. I did mention certain ones that I've not redacted.
We can.
Okay, so
if
we're
it's
not
okay,
keeping...
I understand the motion. We'll get the transcript quickly. Go through those.
So those names that I said have been redacted, they should continue to be redacted.
Right.
And
but I think we'll be able to agree.
And the settlement agreement provisions have not been.
I don't know if they ever talked about it here.
We can go back to the yeah, it's in the benchmark.
Thanks. I don't have serious heart concern over any of those, other than those names that I didn't disclose. Okay. How about next is going to be the defendant's motion for access to corrected and unredacted DVDs produced by the FBI.
Your Honor, I'll try. Oh, I think I bumped this, hope it's still working. I will try and be brief on this, Your Honor, because most of what we have to say about this are in our papers. I just want to set the table briefly and say the following. When there are basically 2 categories of DVDs. There are 5 DVDs total that we're talking about. I'll probably, if it's all right with you, I'll deal with them separately. The first one is there are 2 DVDs of the sting operation that the FBI produced directly to Judge Case. The FBI originally produced them to Mr. Thomas, and who returned them without reviewing them, consistent with the orders in this case that DVDs of all stripes were supposed to go to Judge Case. When we entered that agreement, of course, we did not know that there was video taken of the sting. There was testimony that the plaintiff knew, but we did not know. And so when we worked out that protocol about the provision of DVDs, it was to deal with what we thought were going to be sex tapes, and it incorporated an earlier ruling by Your Honor that if there were going to be sex tapes, Judge Case maybe should look at them in the first instance to see what's what, in an effort to protect privacy of Mr. Belay. But in this instance, there is nothing in the sting video that we know of that in any way involves sex, involves nudity, involves offensive language. It is, as best we can tell, video footage of Mr. Davidson, Mr. Belay, Mr. Houston, fully clothed, engaged in conversation, and is not the sort of thing that ought to be kept from discovery in this case. And we believe that those 2 DVDs should be produced. I know you said that different judges reached different conclusions, but when we were in federal court and we explained this to Judge Buckley, she asked, why is a video of the sting operation going to Judge Case? And we explained that the the background of it, and we thought that it should be just limited to sex tapes, and that was her understanding as well. So here we have, both she and the FBI have had the opportunity to look at these videos, which we of course haven't, so they're proceeding on that basis. So, and we believe that that's the proper way to proceed with the Sting video. We're a little bit at a disadvantage because we don't actually know what's on there, but we don't know if, for example, if there was an overlap with what's on the audio. There may be different things that are there. We'd obviously like to see the reaction of the participants, including specifically Mr. Balea, who is here telling us that he is been injured to the tune of a lot of money for the Gawker's playing of a video that's very brief and has only about 9 seconds of sex in it. And there are other reactions, some of which I talked with Your Honor about earlier today up at the bench, that Mr. Balea had other things on the tapes during the Sting operation. And so we do believe that we should be able to view those DVDs ourselves and make use of them, at least for purposes of seeing them, to see what's on them. With respect to the three other tapes, there was, and this is not undisputed, there was a protocol put in place in this case to incorporate that order that Your Honor referenced, but that order was then changed essentially when Your Honor looked at the tapes and then had 6 lawyers, 3 from each side, come into the jury room and watch an earlier version of these DVDs.
Why was the protocol changed? Because we were on the eve of trial, Judge Case was
I'm not
in our state.
I understand that, but at this point, right? At this point, doing that exercise again with corrected and unredacted versions of the DVDs would seem to make a lot of sense, and then sending them back to Judge Case, which, and I'm not going to rehearse Your Honor, we've already been over our concern about having 2 layers of review. It's nothing about Judge Case, but we're now 6 weeks from trial. If he has to do something, and then invariably one side or the other is likely to bring it to you, including because if you don't, then it's not preserved for appeal. We're going to all have to do this again, so we don't want to do that at all with, in 2 rounds with Judge Case, and we do think that the parties who have already seen the earlier versions of these same DVDs ought to be able to look at them again and see what's on there that would be useful in terms, and I will say that when it was hard to make sense of them because the tapes that had been produced the first time were flawed, but that there was a bunch of useful information on the DVDs, and of the kind, and I don't mean any disrespect to either you or Judge Case, that a party's counsel might think, hey, this is useful in a way that a judge might not occur to you, and I don't mean that in a disrespectful way, but we live, you have lots of cases. We're living with this case and the facts of this case day in and day out, and it may be a little easier, perhaps a lot easier, for us to make sense of what's on there. So for my purposes, and there I understand that there's a concern about releasing them, and I would propose to do the exact same thing that we did the last time, which is when there's not a jury room, the jury room's not in use, to have the parties come and be able to, or the counsel, come and be able to review the tape. Somebody could bring a laptop and look at them, and they could stay otherwise in the court's custody, and if there's something that for some reason we need to use, we can revisit that at that time. But that first and foremost, just for purposes of discovery, we see what's what. And I do think that when you have contemporaneous videotape evidence, right, we have, and there's been discussion with Mr. Barry and with me earlier today about the discrepancies in testimony between the participants and whether or not they are in fact telling the truth, and whether they told the same thing to the FBI and that they told to this court and in these proceedings. That being able to actually see what's there is important. Now, I've put a bunch of things into the brief, starting at part 3 of the brief, that go through in some significant detail why all of that information, what's likely to be there. We don't, again, know everything that's there. We know some of what's there. We saw some portions of these tapes, and they were correct previously, but we didn't see the full corrected version. So, and we've sort of gone through them and thought, well, here are the things that we're likely to see based on that review. We think a lot of that is directly relevant to the privacy issues in the case, to the emotional distress issues in the case, and to the damages issues in the case. And we don't think it's fair to us to be deprived of that, including because, as we pointed out earlier, the plaintiff and Mr. Houston were able to watch at least some portion of these tapes themselves previously, which, again, we did not know when we were negotiating that protocol. I'm happy to go through some of those if there's questions, those specific issues, but I didn't think it made sense to belabor that point and didn't want to take up more time.
Good response, and maybe I have a question.
Very well, Your Honor.
Yes, Your Honor. And I am going to be very brief on this one, but you've already ruled clearly, and I think a couple of times since the trial, that the stipulated protocol would be followed, that these DVDs would go to Judge Case, and that he would review them for relevancy. That was actually the Gawker defendant's suggestion way back when, in January of 2014. They said that basically we have no problem with Judge Case reviewing these things for relevancy. Now, I don't know if this change of heart has something to do with not liking rulings that they're getting now, or with the direction that the case is taken, but at the end of the day, they suggested it, we stipulated to it, and you've ordered it now twice. One of the arguments that Mr. Berlin made, well, it makes a lot of sense, so let us watch them again, because we watched them before. Well, to be perfectly honest, I don't think that makes a lot of sense to Mr. Berlin.
You know why it makes sense? The three videos. There is a question, at least in my mind, as to, are there three separate videos? Is there one video, cut and diced? Are there different things on this video that weren't sent to Gawker on Gawker's 30-minute video that they had? So there are a number of those issues that potentially could ask us of a trial. The sting operation, that whole thing is muddled, and it gets murkier and more cloudy the more I hear about it, because I'm hearing there's a video of it, now I'm hearing there's just audio, well, there's a transcript, so I don't really know that any of us in this room know what's actually on that disc that was sent to, or the two discs, I guess the two discs pertaining to the sting that went to Judge Case. So I see that in the sting ones in a different light than I do the three DVDs. At least the three DVDs, I think it could become clearer as to factually are there three or really just one, cut and dice in different ways.
Right. And I certainly understand that, Your Honor. The concern, however, is that if it is three, and the two that they're going to view have absolutely nothing to do with the one that's at issue in this case. The footage we're talking about, from our perspective, was secretly recorded. So every word he says should be heard. Right. So that's the underlying concerns for us. And I believe we cited to you, Your Honor, in our attorney's eyes only materials, but I think it applies equally to this. The Mueller case, the Friedman case, and the Ryan case. And the Ryan case and the Mueller case are second DCA cases, but they both stand for the proposition that, look, when privacy interests are concerned, the court needs to look at the discovery for relevance in camera before it can be produced, which is basically what Judge Case is doing. Because you can't let that cat out of the bag. And that's our overriding concern with this, is that cat is potentially let out of the bag unless these are reviewed for relevancy first. Mr. Berlin and Mr. Berry have done an excellent job in their papers, quite frankly, of explaining extensively what they believe the relevancy of these things is. That gives Judge Case a roadmap to view them and see if that's there. He's eminently qualified to do that. Certainly familiar with the factual background of the case. And if he has any questions, he can at any time call the parties in to say, hey, this could potentially be an issue, explain your positions. We think, quite frankly, that that's the better approach in this situation, giving the incredible privacy rights that we're talking about in terms of Mr. Balea being secretly recorded, including naked and having sex with someone. So that's what we would be concerned with, Your Honor.
Do you have any comments as to their third point, the ex parte communication with the court?
I don't.
Page 15.
I don't know that I've ever seen anything like that before, Your Honor. And it kind of surprised me. I mean, a lot of what we've been talking about, particularly with Ms. Steele today, was the fact that you shouldn't be keeping things from the public when you're having supposedly secret hearings, and yet they want to do that and exclude a party. I don't know if that's even proper in terms of due process. And I don't think, I mean, there's legion of case law saying, look, we're not a state that supports trial by ambush. You're supposed to flush out your theories. You're supposed to flush out your evidence. Let's get the facts in front of the jury. There shouldn't be any surprise like that. And I know they say, well, we've already identified the documents we're going to use. Well, there's literally, I mean, you saw them, hundreds of exhibits.
Not hundreds,
thousands. So, I mean, I appreciate that. I appreciate that counsel's concerned about their work product, their mental impressions and things like that. But at the end of the day, you know, if they've got a theory, let's hear it. You can decide and we'll move forward. Thank you.
Mr. Berlin.
Third reason, Your Honor.
And on to that third aspect of, well, it sounds inviting, it sounds very complimentary.
Well, let me say the following, Your Honor. I think this whole thing is a little bit problematic because in the normal discovery, we don't, you know, we don't have trial by inquisition where a judicial officer looks at the evidence, decides what's relevant, we have discovery, and that's how we look at it, and the parties get to go and see what's what. I agree with Your Honor.
It's been allowed.
Well, and in this instance, we are saying this has already been allowed once. And I will say, Your Honor, that you look at these, you know, this case has a lot of evidence, and we're trying to reconstruct what happened between Mr. Balea, Mr. Clem, Mrs. Clem, a number of years ago. We're trying to reconstruct what happened in terms of how this tape came to be made public. There's a lot of things that we're trying to reconstruct. And when you look at the pieces of evidence, we've been at this now, 2.5, 3 years. We look at the pieces of evidence. Sometimes you see something that, you say, oh, well, this is, I could go through, and I did in this brief, try and list, here's some things why this would be relevant. But the great likelihood is if you look at the videotaped evidence, you're going to see something that's not on that list. And something that, and I mean no disrespect to you or Judge Case, that you're not going to see because you're not looking at it the same way we are with the same background. And that's really the point of the process. The ex parte submission was designed as a fallback to that because it basically says, look, we have some other things that we think might be there, but we don't really want to, have to, this isn't sort of keeping this for purposes of ambush, but if we don't do discovery that way, and we do discovery where each side looks at their own things and develops their themes, we share the facts, and then you put it all together at the trial, and we shouldn't have to, if we have the unfairness of not being able to look at the evidence ourselves, then we shouldn't compound that by the unfairness of to be able to give Judge Case at least some sort of, or you, or who's ever going to do it, some sort of roadmap that's going to disclose our work product. That was really the point of that. I don't disagree with you that it is an unusual suggestion, and we were trying to think of, when this came up in the protocol, it's referenced in the protocol that we can ask for this, which is why we did. We said, well, this would at least allow us to deal with this sort of unusual way of doing this particular discovery. Now, again, that was before we had already looked at what is essentially, and as I understand the lay of the land here, the video footage, the problem with the tapes as they first were produced was largely, not exclusively, but largely an audio problem. And
visually. And really the whole thing starts about because I thought I was getting the original tape, so here I was quite worried about somebody seeing the tapes that wasn't supposed to be seeing the tapes. All the folks that wander through the courthouse all the time.
So for your purposes, I agree with you. And then if I just make one last comment about the sting operation, Your Honor, I don't disagree that there's a murkiness to this, which we're still trying to sort out. We have a video, we have a transcript, we have an audio, right?
I don't think anybody has a video, right?
Well, we don't have it, but Judge Case has this video of the sting.
He has a disc. I'm not sure if there is any audio or if it's only hearing or if there's anything really recorded. I understand there were no cameras, so I don't really know.
My understanding, and for what it's worth, there's testimony about this from the participants, that there were cameras, that the rooms at the Sandpearl Hotel where this sting went down were in fact pre-wired for video, and that the audio comes from a separate place, which is that I understand Mr. Houston was wearing a device that recorded audio or transmitted audio. I'm not sure which. And the video, my understanding is it does have sound. We asked this question of we've had problems with production of video or of audio from the FBI previously, as Your Honor is aware. So in an effort to try and close things down with Judge Buckler, we asked the FBI, are you sure that this is a proper recording? And, were you able to resolve? They at some point had advised there was a problem that the audio track on one of the two discs didn't play, and they came back and said they solved that before they produced it to Judge Case. And that we took up with Judge Buckler. But my understanding is that there is this video. It's from, as I said, a different perspective than perhaps the device worn by Mr. Houston. And the issue there is that I understand why we went down this road with sex tapes, right? Because you got people having sex on them, right? That's where we started. This is the suggestion, and it's not, Mr. Vogt said it was my suggestion. It wasn't my suggestion. It was Mr. Harder's suggestion as essentially a compromise proposal at that hearing back in January of 2014. And I have the transcript if Your Honor wants to see it, but that's not the point. That's not the point. The point is that we went down that road with respect to sex tapes dealing with privacy. That's already now not the same issue because we've all looked at these tapes. But with respect to sting operation, where you've got people sitting in a hotel room, three men fully clothed talking with one another, you don't have the same privacy interests that would compel having somebody, not the parties, being able to see the evidence. And if Your Honor wants to keep possession of them and have us watch it the same way we did, you could do something like that, but we should at least be able to see that ourselves. And especially, I will say this, that although, Judge Case, I think, was last involved in a substantive way in this case at this point about 9 months ago, the bulk of the discussion about the sting and the FBI investigation and all that has come more recently, and again, mean no disrespect to him, but he's much less familiar with what that's all about, what would be relevant, and that's why, because there's no privacy interest, the parties should be able to look at it, and I think that's true not only of us, but the plaintiff. We should both be able to look at it. So that's what I would have to say, Your Honor.
So why, as we sit up here at the bench on page 15 here, in the alternative ex-parte proffer, it seems to me, I don't want to do the ex-parte proffer because I don't think it would be appropriate, and I'm concerned about other ramifications for that. But that potentially is something ideally heard by a special magistrate, such as in Judge Case. Why would that not be the appropriate measure? Well, separate and apart from the part that you objected to.
Right.
Disregard that for a moment.
Look, it's the heading is titled in the alternative. It's designed as an alternative relief. The preferred option here, which I think is, especially as we're all 6 weeks from trial, we have a lot to do, is set a date, get the parties in that room, let them look at these DVDs, and move forward. But if we're not going to do that, making that proffer, here's the issue in real life, is that and this is true more generally, but it's also true with this proffer. If we were to go to Judge Case it is my prediction, given the importance of what may be on these DVDs, which are contemporaneously recorded video, that one side or the other will take exceptions to you, including because they may need to for preserving that issue for appeal. It's my understanding of the Florida rules that if you magistrate judge rules and you don't do that, you waived it for all time. So what that probably means is that same issue is going to come to you. That same proffer is going to come to you because you're going to have to review whatever proffer was made, and that just adds another layer to it. But that's my own view. And I also believe, Your Honor, in the same way that you're not the fact finder here, right? So we're not worried about your being, getting evidence that you don't.
But maybe you misunderstand what you're saying as a proffer. I'm interpreting from page 15 is that you want to proffer some additional theory, not facts. You want to proffer an additional theory that you have that would support why the showing or revealing of these DVDs would be important.
Right. I think what we would like to do is to provide additional things that we think are likely to be revealed by these DVDs. Facts or theories? Well, they would be facts if they showed up on the DVDs, otherwise they're theories. But the point is, and I'm not trying to be difficult in answering your question, we would like to be able to say, look, when you review these DVDs, here are some additional things we think you might see that would be important, and here's why they would be important, which is, I guess, both a fact and a theory. And then to do that without also disclosing that telegraphing essentially our work product to the plaintiff. That's the point of the ex parte.
So this is an alternative to me saying, here you go, look at it. You're saying you want to give me additional things to look at when I'm looking at it.
Right. Obviously our preferred option, both because I think it's easier for you and also because I think it's probably better for us, not just us, but both sides. I think it's better for both sides to be able to see what's there and to be able to bring to bear their own knowledge of the facts, which is more nuanced and more robust than you could possibly have time for in any given case. And again, I mean no disrespect. This just is what it is. That's the preferred option. But if that can't happen and you say, no, I'm going to review them, or if Judge Case is going to review them, then we would like to be able to come in addition that we've listed a bunch of things. Here's what we think might be relevant. Please look for these things. We have a few more that we would like to be able to come and point to. But that really is a fallback position. I think our primary position, as you said, is look, there's things on these DVDs that we want to know. Is it three separate ones? Is it one video? Are there other issues about these things? What do they show? And to be able to bring that to bear, it will undoubtedly raise an issue if we find that kind of thing. What do we do with it, right, evidentiary-wise? But the first thing is just the discovery thing to find out what's there, and that's really where we are. And we would like to, I think, be able to do that with these 5 DVDs. 3 because we've already done it, and 2 because they don't really have anything private on them.
Well, I guess whether they have anything private on them matters.
I'm sorry?
Did you say that whether or not they have anything private on them?
No, I said 3 because we've already seen them, and 2 because the 2 Sting ones because they don't appear to have anything private on them. Right? The initial justification for having this procedure to begin with was sex and nudity. We don't have that on those 2 DVDs.
So I see lots of chatter over points to label. Was there anything else additionally you want to say, Mr. Vogt, as to that particular motion?
No, Your Honor.
Okay, I'm going to ponder that one. So let's continue. So I'll reserve technically. And as to the or I don't think there was a confidentiality to that one. All right. So
Your Honor, actually, there was also for that one.
Okay, so I'll ponder that whole thing.
All right.
So let's talk about your questionnaire. Oh, I guess no. Plaintiff's motion for issuance of letters rogatory.
Before we leave the confidentiality stuff, since we're here, as you did on the last one, you might get. Our position is it's fine. We can do this because we're required to. But you might just ask for the plaintiff's position since it's their word to see what pieces of this they didn't object. We have no response to the confidentiality question.
And we do object. A lot of this is just regurgitation of what's in the motion to dismiss for fraud on the court, including numerous pages reciting the same fraud on the court arguments and evidence. It's not as simple as really the arguments we've been talking about here today. There's a lot more to this. There's a lot more involved in the motion to compel.
Okay, so let's move to plaintiff's motion for issuance of letters rogatory. Mr. Bennett, please.
Yes, Your Honor.
And I don't know if you have all the materials in front of you, Your Honor, but we had a proposed subpoena. This is to obtain trust documents relating to the family trust in the UK. And I know, at first glance, because there are a number of items listed in the subpoena that we're asking for, it seems like, whoa, that seems to be a lot more than what we had originally talked about. But the reason is really twofold. Number one is we've been working with UK counsel, and apparently the way the process works over there is you have to specifically identify the document that you want. You can't use categories of documents. So you have to, we've used sort of alternative identifications of these, not knowing which one may fly with the UK courts to get us the information that we want. And I think we've been overly cautious there because, quite frankly, we're short on time. We're only going to get one shot at this, and we wanted to make sure that we attempted to phrase things in a way that we could get everything that we needed. The other issue on this, Your Honor, that I think is critically important, I know that there's been some objection and a motion lodged with respect to the subpoena seeking information regarding an entity known as Gawker Media Limited. And I did want to briefly explain that to the court because it's probably a new issue. But you may recall when we had the hearing on this, and I've got the opposition papers, but there were representations by counsel as well as testimony from Mr. Denton that his niece and nephew own shares through a family trust. It turns out that's not true. What it turns out is that those shares are actually owned by this company, Gawker Media Limited, and that his sister, according to documents that we obtained from the UK corporate registry, is 100% shareholder of that company. Now, obviously, that's vastly different than what we had originally been told. That's why we're seeking documents relating to this company, Your Honor. In addition to that, we're also seeking some specific information regarding a loan, and this is why this is important.
I'm sorry, regarding
a loan. This is why this is important. In 2013, the shares that were originally held in the trust, during the pendency of this lawsuit, the shares are transferred to this UK company. At the same time, the UK company borrows, according to its filings in the UK, an amount of money a little bit in excess of what it says the value of those shares are. We want to know who they borrowed that money from, whether it was actually borrowed. It raises a lot of questions as far as we're concerned. Even more so because when we did some background, originally when this UK company was created, it was incorporated by a gentleman by the name of John Duncan, who's a lawyer out of Chicago who specializes in setting up asset protection and family trusts for extraordinarily wealthy families. Around the time that the shares were transferred from the trust to the company in the UK, Mr. Duncan transfers his shares to Mr. Denton's sister. So we have some very serious concerns about that, and as I said, we only have one shot to issue this subpoena to the UK. The position that's been taken before, Your Honor, is that Mr. Denton has no interest in this whatsoever. So quite frankly, for purposes of today, I don't think they have standing to object to this. This is going to be subpoenas directed to third parties. They'll have to go through the UK. They'll have every opportunity there to object based on privacy or any other grounds. They'll be fully protected. So at this point, we would ask that Your Honor issue the letters rogatory with the subpoenas as they're drafted so that we can at least get the process going on getting this information.
Your Honor, first, I'm not sure I had all of that. I'm not sure I got all of that. I heard basically, without any factual showing, a bunch of testimony from Mr. Vogt about shares in a different company being transferred, the involvement of a lawyer from Chicago. I must tell you, I'm not sure what all that means. I have to say, I'm not sure what it has to do with this case. Right? We went down this road, as a reminder, Your Honor. There was a question as to what Nick Denton was worth, because he's a defendant. None of these other people, of course, Gawker Media Limited, I think is what it's called, Mr. Weinbrecht, Miss Denton Weinbrecht, Mr. Denton, the father, I don't even remember all of their names, none of them is a defendant. And so what we have is a situation where they came to you and they said, we think we need this trust, and you'll notice we have a motion for reconsideration as part of this. We think we need this trust because it will show somehow that Denton and his family members who own the shares, and I don't know if they own them, directly. I mean, it sounds to me like he's saying there's some sort of corporate structure to own them. I don't know if that's true or what that means, but Denton and his family own shares, and if they own them together and they're worth together more than 50% of the shares, those shares are worth more because together they control the company. And if they sold all their shares together, they'd be worth more than some other person's shares who doesn't own control of the company, because when you buy a controlling share of the company, the argument goes, that's worth more. I'm not a corporate lawyer and corporate share lawyer. I couldn't speak to that. But when I mentioned that to a colleague who is, they said, well, that doesn't make any sense in the context that you're talking about, because in this context, you're not trying to figure out what the shares of Denton and his family are worth. You're trying to figure out what Denton's shares are worth, and Denton does not control the company by himself. It's undisputed that his shares are under 50%. So if he were to have to sell his shares because there was a punitive damages award in this case, or if the jury were trying to assess the value of his shares to do that, those shares are worth the same as everybody else's shares. And we've now gone down this road of, expansive discovery to family members in the UK and his nieces and nephews who are minor children to find out what their ownership share is, all for naught. And so my first position, Your Honor, is we ought not to go down this road. We all have a lot to do in the next 6 weeks, and this is not going to make any difference to the outcome of the case, number one. Number two, if we're going to go down this road, and we've got all of this testimony from Mr. Vogt about what this company is and somehow how it's connected to these people and so forth, if he's going to ask you for discovery on that, it's incumbent upon the plaintiff to come to you with facts in evidentiary form, an affidavit, attach some document. We have documents that show me the documents and let us be able to respond. We can't even respond to that. And I do think that on the one hand, Denton might say, well, I don't have these documents. It's not my trust. I'm not involved in this, and I don't care. On the other hand, he does care that he's a defendant in a lawsuit and that his sister and his niece and his nephew and his elderly father are going to get harassed by some British process. He does care about that, and any of us would, right? You came and if I had foreign family and you came and said, I want some information from them because you're involved in some case, I would say, well, wait a minute. Let's make sure.
Transfer property or money to them during the pendency of the case, I think could be relevant.
Yeah, but that's not what he's saying, right? What he's saying, well,
that's what he's saying.
The testimony on this is clear, Your Honor. The part of these shares that were Denton's predated the case. What they're saying is somewhere between Denton's family, as I understand it, I'm just reading from my notes and they can correct me, but again, this is why we have unlike the brief we got yesterday, our opposition to this was filed about 2 weeks ago, and we could have easily, put this in a reply. It's not the kind of thing you put in a reply, but we could have been warned and come and had an intelligent conversation about it. But my understanding is what he's saying is that the family originally held shares in trust and that they then transferred those to this UK company, right?
I think that's what he said.
Are you saying you have documents that show Mr. Denton during the life of this case transferred these shares?
We have documents showing that the trust shares were transferred into a company.
Right, that's what I'm saying.
Not Mr. Denton's trust?
Well,
It's not listed.
it's the family trust.
It's his sister and his brother-in-law's trust. And they're saying, there's Denton over here, you've got the trust over here, and apparently some company. And they're saying, these two over here had a transaction, and somehow that bears over here. That's what I get from this. I'm not sure if I have that entirely right, and if I had actual facts in front of me, I'd be able to respond intelligently. But it does seem to me that, first and foremost, we ought not to be going down this road. And if we're going to go down this road, right, the first thing that Mr. Bode said is specifically identify the document. Your Honor, the last time we did this, you specifically identified a document, which was go and get the document that established the trust, right? And we sent in a proposed order, which we all agreed on, that that's what the thing says. Then we get this motion, give us a letter, and it's got, I think we counted up 117 different requests for documents about all sorts of things, tax returns, annual reports. You know, we couldn't even get Mr. Belaya's tax returns, and he's a party, and now they want the tax returns of a trust in the UK. It doesn't make any sense. Tax returns, annual reports, stock summary, stock certificates, stockholder reports. Right, and then they want the tax returns and the income statements for Gawker Media, LL Limited, this other company. Right, so we're now to a point where I do think that Mr. Denton is looking at this and saying, look, I disagree that I'm liable in this case, and I certainly disagree that I'm liable for punitive damages in this case, but if I am, then so be it, and my net worth is fair game. And he's sat for deposition after already being deposed earlier and answered all manner of questions about that down to the level of what his wedding ring is worth, right? We've had a lot of discovery about that. But when you get to the point of saying, okay, now we're going to get his family involved, and to this extent, we are, and he's already said, he's put this under oath, he does not have the documents. So we were basically saying, you know, you got to go, and if you think this is important, then you go and get it. And what you said at the last hearing was, okay, then that's the document. Now, in response, we see what this looks like. We say, well, that doesn't make any sense. And having had the benefit of actually talking to a colleague who knows something about corporate law, when we sort of visited with them about this control theory, they said that doesn't make any sense in your situation. It makes sense generally. If you were selling a company, if Mr. Denton and his family were going to sell all their shares together, they probably could be worth more, right? I'm not sure it's saying that they are, but at least I understand the theory. But that's not at all what's happening here. We're asking the specific question is, for punitive damages, what is Denton's and Denton's alone net worth? Well, in addition to Gawker and Delario, but for this purpose, Denton. And so I would say, we all have a lot to do, and I would respectfully request that Your Honor reconsider the earlier holding based on the additional explanation that we've given, and say, let's just put a pin in it and not go down this road. And that's what I would have to say. So.
And sort of problem we've had with this all along is that we're supposed to take Mr. Denton's word for it. The word that he gave, and that was put in their opposition, and this is dated November 12th of 2015, is, quote, the point of the argument is that those family members, his niece and nephews, also own shares of the company, but that fact is both undisputed and already the subject of sworn deposition testimony. Well, if we had taken his word on that one, we wouldn't have found out that there are records indicating that, in fact, his niece and nephew didn't own it. It was transferred to this other company. We're acting on this assumption that this trust document doesn't give him some sort of right or interest or reversionary interest, but we've never actually gotten the trust document to test that. And in the interim, when they fought so hard to keep us from getting this trust document, now we have this revelation that apparently something happened with these shares during the pendency of this case, whereby a company that is wholly owned by Mr. Denton's sister, and I have documents, if I know that Mr. Boleyn asked about them, I can show the court and Mr. Boleyn the documents. And one of them, Your Honor, I know they have, because they produced it to us during financial work discovery, the document showing that the shares were transferred in 2013. That would have been prior to this response being filed when Mr. Denton testified, and then it was represented to the court that his niece and nephew owned them. But At the end of the day, all we're trying to do is figure out who owns it, whether he has some sort of revisionary interest, or whether there was some other mechanism used to either protect shares, hide shares that were potentially his, which could be a fraudulent transfer, as you noted, or whether he has or still maintains control somehow over this company, which I know that they disagree, but our expert believes that control premiums are actually an important issue and could affect value at the end of the day. But I think that we shouldn't have to fly blind on these issues when there are a lot of unanswered questions as to the trust, the company, the transferring of shares during the middle of the lawsuit, and even this loan, Your Honor. I mean, as we sit here today, the fact that these shares were transferred by the trust into a corporation that's wholly owned by Mr. Denton's sister, and that entity apparently borrowed money in excess of those shares, that raised concerns. Well, where'd that money come from? And two of these are public that we got offline. This one.
I can't hear.
Okay.
I'm going to hand it right back to you.
Okay. No, Your Honor.
Briefly, Your Honor, I think if we're going to go down this road, I ought to be able to ask, my client, and this is, sort of a lot to digest sort of on the fly, but let me tell you what I make of these documents, which is, it looks to me like there was, as best I can figure out, and I don't know if this is right, but as best I can figure out, that probably for some reason having to do with UK law, that the trust put the shares of Gawker Media Group, which is the parent company that we used to have in this case, into this company, Gawker Media Limited, and because they have to, they register those transfers. There's paperwork that we had. We didn't hide this. This is has our Bates number at the bottom saying that was done. And then you have the documents that they've pulled from the internet about that company. And as best I can tell, it looks to me like Ava Denton, who I guess must be Mr. Denton's sister, who was the parent of Ava, Luca, and Remy, they're listed here as the three minor children, appears to be the shareholder of that company, and I suspect it's the same thing as being, held on their behalf. I don't know. Of Mr. Right, but it's Rebecca's. Right, Rebecca's children, not Nick's children, sorry. So his sister's children, right? Sorry, thank you. If I misspoke, this was confusing enough. I want to make sure I get it right. So it looks to me like they took what was essentially a trust that Mr. Denton had some sort of passing familiarity with. He testified about it when they asked him about his deposition. And said, look, my sister has a trust for the benefits of my nieces and nephews. Truthfully testified about that. It looks like for some sort of reason it was put into a company. And then there's this question about a loan. But if you look at what the loan says, let me get to that page, it looks like the loan is an unsecured loan and notes due in 2028. And I'm not a tax lawyer and I don't want to, I'm just guessing, but usually when you have notes that are due over time and then you reverse engineer what the value is today, it comes up with a different number. And I would, is it possible that they borrowed more than the company is worth? Yeah, it's also possible that they borrowed something in that vein, and that's the way it gets reported on the financials. And all I can say, Your Honor, is I couldn't imagine what that could possibly have to do with this case. And so I think that the discussion that we've just had, while fascinating, and if there's, if the court desires, I'm certainly happy to go to Mr. Denton and promptly ask what it is that he knows about it, which if I had been given these materials any time before today, I would have been certainly happy to do. But I generally think for purposes of what's at issue today, which is are we going to send letters rogatory to a court in the UK and ask them to institute some full process over this, this actually proves my point that this has very little to do with this case.
But I think to your earlier comment, this really goes more to the punitive damage discovery aspect. That's the follow-up from all that, right?
Correct.
Didn't this all come from the punitive damage aspect?
Yes, Your Honor.
All right, from that standpoint, I'm granting it. All right, now let's talk about the jury questionnaire. So, you sent me a copy of their proposed second questionnaire. And but in her cover letter, it says we've reached an agreement on a hardship questionnaire. Anybody have a copy of the hardship questionnaire?
Rose. It says what I'm giving the hardship questionnaire and the cause questionnaire as agreed. There are additional questions they wanted to add to the cause questionnaire.
This is a lot of copying. Somebody's going to be responsible for taking care of it overnight. Okay, so the jury questionnaire hardship This would be given to the jurors on that first day, everybody, and then this would be the top part that we would talk about. When I was mentioning earlier today the part about a colloquy, the colloquy would be as to what is it that you all agree that you want to say briefly and initially to everybody, to tell them this is the case that you're here for, and you're going to be here if you're chosen for X number of 2 weeks or whatever it is. Like, is there anything that you have going on in your life that would take your attention away from this trial or any needs to be served?
That's a good question.
Do we have, it's in the hardship questionnaire?
Right.
It's the hardship. If you look at number 5.
Yeah, and we would one by one meet with these people.
The hardship people or the cost people?
Hardship.
Really, actually.
You would,
Well,
I think.
hardship and cause sometimes can be blended. So,
I'm open for anything. I'm open for a process that works.
we'll
So,
roughly have 150 people coming in the morning.
Right.
If we ask for 500, we're roughly going to have 150 in the morning, 150 in the afternoon. So the way I saw Judge Day do it was hardship and causes. And I had reviewed Ms. Dugate's her questionnaire, and some of the causes going into relationship with Mr. Valea. You know, those kinds of, I'm not talking about those kind of causes. Causes that, well, I guess to some degree they would be, but easy ones. I'm not talking about when we're sitting there really, you all are talking to the prospective jurors.
let's kind of, when are they going to get the questionnaires?
That morning.
Okay, that's what I thought. So it's just like a normal trial, except instead of getting the 5 questions they get on the little jury slip, they're going to get all this rigmarole.
Right.
So we'll have those back and arguably have, what do you give us, maybe an hour to go through it?
If that.
If that.
And Judge Day is doing it again. I believe the date is January 20th.
And what trial?
He's doing it, it's a tobacco trial. And so
Sure.
they've got similar number of folks coming in, and this is what I saw him do the last time. So they bring them all into that courtroom on the first floor, which is just one big large room, and they had a questionnaire, I imagine similar to this kind of questionnaire. And so they didn't even make copies of these. They, one by one, came up and said, oh, I see that you checked yes on box 5. Why is it that you can't serve? Okay. We look at the attorney, they say, well, I just started a new job. They look to the attorneys all nod their head.
Do that just as to your hardship group first.
Right.
I can't sit here for 3 weeks. My daughter just got put in the hospital, all that stuff.
And some of them would relate to, I've been a smoker all my life. There's no way that I could rule for the plaintiff.
That's where I think we could do it all at once. I mean, certainly we could do it all at once in the sense that, we're going to have all the questionnaires done, go through the hardship first for people that have indicated anything that's going to affirmatively give them a problem. And Judge, 100%, if it's working for Judge Day in the tobacco cases, who's trying those locally that I can maybe bounce it off of and just see what they're doing?
Jimmy Gustafson, I think, is the main plaintiff's lawyer. He used to be with Tom Mountain, but now I think it's Searcy Denny.
Seriously, Denny's doing them, and who's doing the defense? Is it like Troy Furman in that group, or?
I don't even know who's doing it. It wasn't anybody I don't.
I think we figured that part out. I think my biggest concern is going to be this. I'm not as worried about the hardship stuff. That's logistics. That's, people that just can't be in a courtroom. I've done that drill before in med mals and stuff, and 6-week trials. I mean, that stuff just has a way of easily weeding stuff out. I'm going to be much more concerned about whatever dialogue we're going to get into with people that may have been following the case, that may have seen some of the more prejudicial type press, where I think, the obligation to get into a little more detail before someone, but both for the court's benefit to protect the record for all of us, and if we get in fights and we don't agree, because I'm sure someone I want to challenge for cause from bad media exposure may be someone they desperately want to keep.
But that's
So,
the next day.
right.
I see that as a different day, and you should have copies
Okay.
of those questionnaires at that point.
And,
Hardship questionnaire,
but you used the example of someone saying I'm a smoker, which really isn't hardship as much as it
it's
is
not,
cause.
but it tells you immediately.
So obvious cause
It's an
problems.
obvious
Okay.
cause problem. I used to be Hulk Hogan's girlfriend.
Something like
Things
that, yeah.
We were trying to-
Or Seth Berlin's girlfriend, for that matter. Yeah.
Exactly.
The,
Although he's from out of town. So, Mr. Thomas.
Okay, I got that. So we'll do the sort of obvious kind of, fat pitch ones early, get that out of the way, and then move into a secondary cause phase, which will take the bulk of the time.
And that's like the next day.
And then we'll just be full on regular voir dire at that point, then. Yeah, okay. I'm good.
I thought when we discussed this, we visited on this earlier, and that was my understanding, that we were going to do the hardship questionnaire, could bring all these folks in. Are we going to do that in the jury assembly room down there on the first floor?
Yes.
Okay. That we're going to do that, we'll call out these hardship folks, and then what we'll do is we'll give them the second questionnaire. We'll have these folks complete that. We'll make the copies. We'll study that. We bring it in for days 2 and 3, and then we do a proper voir dire.
Yes.
On that, I had a question for you as well. I take it from something you said earlier that we would do that kind of in tranches. We would do 24 jurors, go through voir dire.
I don't think we've made that decision yet.
Oh.
And I think that Mr. Pretrial, at one of the more recent hearings, is that he was still weighing the fact that they're individual, one by one. I don't know if he's still there.
I don't think I have a choice. I don't really want to do it that way. But I don't know, frankly, to the extent I get information. The only thing I personally really cared about on these cause questionnaires, with all the sort of let's figure out who they are and the joy of getting an advanced type of questionnaire like this, which we normally don't get. We usually get, have you been a witness to a crime? Have you been in a civil lawsuit? Is your relative LEO? That was LEO. What I'm really concerned about, judges, when we get into who's read what, who's followed this case, and I just can't get my arms around whether there's any way to do it that wouldn't require some sort of involved examination in chambers. Because I'm going to poison, if I start getting into it with somebody, it's clearly going to poison the rest of the group. And if you've got people there that haven't heard any media or haven't followed it, in some respects that's kind of a dream juror for us, right? We don't want them to sit there and have people in a colloquy with counsel over, oh yeah, I followed everything. I read about the stuff that went to the Inquirer, and I read about Gawker's thing with the executive. I've read everything that there is out there, right? We don't want those people examined. I don't think, I would imagine, Judge, you don't either. I don't think we want them examined in front of everybody else. I think we're asking for trouble if we do it.
What do you say, Mr. Sullivan?
I think what you could do, Your Honor, is when you get the cause questionnaire, you could identify some people that look like they would be particularly problematic, and you could do those. I think you should weed out those folks that you would be most concerned about, take care of them, and then I think you go to a traditional voir dire process, and I think that would probably work.
I would say this, Judge. Let's take a look at what the questionnaires tell us. But I've just been into what I like to call the blood and guts part of voir dire, where people just start saying, you know how it goes, Judge. I was sued for defamation once, and here's what happened to me. And I sued somebody for fraud once, and all of a sudden everybody just starts talking. And life experience just becomes the courtroom, and I'm just a little concerned that there's a broader scope of things for them to talk about, from whether they watched WrestleMania in 1984 to, I've got to deal with, the other stuff that may have gone on with my client. There's just a lot. I'm scared of tainting entire pools. So here's what I would say. That's my long-winded way of saying, I think the process of taking a look at these cause questionnaires, kind of getting together and reassessing at that point makes sense. We have plenty of time, Judge, and at the end of the day, I think if I have to Well, we set, what did we set, 3 days this time?
That's not plenty of time. One side, the whole day, you're doing just hardships, and then the next 2 days, you're doing
I'm not just worried about hardship. I think we'll bang that hardship out in a half day, but I get it.
You've got two groups of people coming in.
Yeah.
So it is half day. Half day for the first group, half day for the second group. 150 people in the morning, 100.
And maybe I think, Judge, maybe the best way to do it is this. We do it that way. We get done with the first day and the hardship stuff. Now we have time to look at these questionnaires more carefully, and we can reassess then whether I need to bring them into chambers or somewhere private one-on-one. But just, Judge, at least conceptually, I need to know if the defense and the court kind of share my concern about why that would have to happen.
I understand that. I think it's fine. Okay, so let's talk about the jury questionnaire for cause. And this is what you can do, Mr. Pretrial saying that it's agreed. So several things. One, it needs to have page numbers on top of every page. Two, just something that just quickly jumped out to me was question blank. Cameras may be allowed to the courtroom. Jurors will not be filmed. Anybody wanting to film the jurors?
No.
I don't know how we guarantee that.
Well,
I think that has to.
we have one camera that it would be a full camera, just like this.
Facing towards the courtroom, away from the juror box.
Yeah. Well, yeah.
Your Honor, as my colleague pointed out, really, media may have a different view than the two of us.
Right.
So,
Well, maybe just striking that. I don't think that we can give it guarantee that they're not going to be filmed. So while this may be reasonable, I think you have to say jurors will not be filmed needs to be taken out.
I'm fine with that. I'm not passionate about telling them one way or the other.
Okay, and so in the one that Ms. Fugate sent to me, have you evaluated that, Mr. Turkel, and you ruled some of those questions out?
This is the one that says, that looks like this?
Yes. Yes.
And this is the one, so yeah, I circled the different, or Shane circled the different ones, the ones that are circled.
Those are the ones that Mr. Sullivan told me that he would like to include within the cause elements of the legal form.
if I could speak to that, Your Honor, here's what happened. We worked together on the hardship one and the cause one. And we both exchanged, 3 copies of each, and then we said to the plaintiff, we'll make comments on yours, we'll give you some broad suggestions, which we did, and they accepted those. And we invited comments on ours. And one of their general comments was, these yours look pretty long. We said, okay, fine, we'll take a crack at paring this thing down, which we did. And then we provided it to them, we said, could you get back to it and give us comments. And in fairness, I think they were busy with all manner of things, so they never got back to us and said what their views were. So we thought the prudent thing to do was file that one. And neither of us can read your mind in terms of what what you were looking for. What I can tell you is that ours is, this becomes no surprise, it's a little more detailed. And I think it does help us get at some of these issues and may either save some time in order or allow us to pinpoint some of these what may be sensitive matters.
Well, pages 2 through 4 are pretty basic. I think, who are you? What do you do for a living? Are you retired? What's your level of education? What have you been jury for? What's your prior litigation experience? I think those are pretty standard in every case.
They really don't get, they're much shorter what they normally get. Obviously, they just get, and here's my concern, judges. I don't want jurors to come to the courthouse and feel like they're taking a test and being burdened before they even sit down and get questioned. We were sort of on the side of less is more, and we have one that's agreed upon. And so in that respect, it's kind of like, we know this one works. There are some questions that they put in their version that I think are both dangerous for a written format and are going to be routinely talked about during voir dire. At the end of the day, you can't get around the fact that you're going to have to sit down and talk to everybody. And a lot of this is just stuff you talk to them about. So,
okay, so let's play this out. Just the basic information. And let's say, Mr. Turkel, we do it your way. And so we look at some of these ones that are on their agreed upon cause, issue, and they put some things in here that are concerning, so we're going to talk to them. So we're going to bring them in and talk to them and ask them what do you do for a living, individually, one by one.
No, I mean, if we're just restricting, you talked about 4 pages of stuff there, Judge. If we just want to get, I think we get that on the standard. Are they going to get the standard little thing they get when they come here anyway? That tells us what they
did.
did.
Replacing all that.
Oh, well then clearly everything that's on the little slip they normally get, we need to ask here. So that's fine. I thought, got it.
But now, all the stuff that's on the standard clerk form is like 1 page. So it is your pages 2 through 4 are pretty much finished. And I don't think, I'm not sure exactly, but I don't think it has education, level of education.
I don't know that it does. I think you're correct. If we looked at the standard Pinellas County, I think it's a 1-page item folks get. I assume it's when they get their subpoena.
No. When they come here at 8 o'clock in the morning, they watch a little video, they get that, they fill out that form, and that's it.
Okay.
And then moments, seconds, before the jury walks in the door for us to pick, here's your pink copy, here's your yellow copy, let's go.
Here's your chart.
Yeah, and your chart. Yeah, but you don't really get much time to look at any of that. Where with this, I think this is a little more detailed. It's generally stuff that I have them stand up and explain.
Yeah, I don't.
And Mr. Berry and Mr. Sullivan came to the December jury trial, so they saw how we went through a normal.
That's what we were trying to address. We're trying to build that into, this form.
Judge, so look, here's the standard Pinellas form. I mean, at the end of the day, if we want to just cover using what they did, nothing there bothers you, then we can integrate that into the agreed form. I thought they were getting the standard Pinellas form. I didn't realize that. No, I always talk about the little slip because by the time I get it, it's just this big. And
it's seriously.
Yeah, I got you. Okay.
It's a 1 page. I just think they've been a little more detailed in some of that same stuff that they've been telling me.
That's fine.
Okay, then looking at pages of your 5 and on. You list the witnesses and the attorneys, which I think that's fine. And I think you, in the agreed upon one.
You're usually going to read witness and attorney list to them anyway.
Well, I don't know if you, even on the standard agreed one, it doesn't have a page number. But second to the last page, question number 23, on the following page, you will find a list of potential witnesses.
Yeah.
So I don't have any problem with that.
That's fine. I mean, I'm used to the courts doing that, but
see it in writing, and I'm fine with that. So with that in mind, Mr. Trick, I'll take a minute and go back and look, point out to me which ones, pages 5 through whatever, and on yours, and theirs, what's different?
Judge, here's what our thoughts on it were. This one, the unnumbered page 1, has agreed upon questions relating to cause. They have a lot more questions relating to cause. I think the more these people write, the more problems we're going to create vis-a-vis arguing about cause. I think some of it is covered broadly enough in this, what are your thoughts, opinions of any of the case, and then write narratives about this case down here. They're going to sit there, they're going to be working forever on this form. If you go into the second, page 6, what impressions, feelings have you formed about Terry Bollea? I mean, those things are going to be covered in the other one. Keep going down. Those may be covered in the whole, have you heard about anybody involved in this case? Everybody's going to check him. I mean, we're going to have to deal with that anyway, so.
Well, clearly, whatever they put on their form, even if we use the plaintiff's long form, the defense long form, then we still have to talk about them. It's just a matter of what form we're going to talk about.
Right. So they're broad enough topics that we felt like shorter was better, less was more, because the more they have to write, the more then they get. I mean, I know how it goes, Judge. They show up, they watch that video, they sit down there for a little bit. They can get a little punchy as the day goes on, and they're going to get punchy enough with what we do. So.
Well, the first morning, they're watching the video and we're doing hardships.
Right.
As soon as, like in the morning group, we finish, you're excused, thank you. Oh, thank you very much for that you don't have any problems. Please go over and sit on that side of the room, fill out this longer form. We have another form for you. We'd like you to come back tomorrow at 9 o'clock. So then, at the end of the day, or halfway through at lunchtime, we gather the one group of long forms that we have. At the end of the second half of the day, we gather the other part of long forms that we have. You all take them, you copy them, and over the course of the evening, we return to the courthouse the next morning at 8 o'clock. We review them together or separately for an hour. You all will have had them over the course of the evening. I won't, but you will have over the course of the evening because you need the copies that night. You read them all night long. And then the next morning, when they come in, we'll have an hour from 8 to 9, I would propose, to talk about it. And then starting at 9 o'clock, we'll tell those jurors that we asked to come back. Depending upon how many, I guess we tell them all come back at 9. Now, on that Wednesday when they come back, there's domestic violence court going on where they work. So they will all be coming to courtroom A on the 4th floor, where we walked up and saw that courtroom. So there's going to be somewhat of a problem as to where we want to put the people that we're not talking to. Maybe they sit in there. My chambers is down here. There's a tobacco trial, a probate case, and this case, and they're all sort of happening in between themselves. So it's not like we have excess rooms where lots of people can just.
They're doing domestic violence down in the jury room, the big jury room?
On Wednesday, which is the second day. So we don't have a room for them.
You can't put them up there. Are you giving this courtroom up for a tobacco or other trial?
For Judge Minkoff's trial. Judge Minkoff has another trial. Well, I don't know who's going to have the trial, but all
somebody's going to be using.
So
you can't put the extra jurors in here to wait while we're up there.
We've got courtrooms and they'll all be used.
I could keep my house and provide a shuttle.
I'm sure Mr. Berlin did that.
Seems impartial to me.
You can guard them. I'm just throwing it out there. Okay, I don't know how to
So then
do
that's why
that.
there's some facility issues that we have to deal with. And some of those, I think we're just going to have to wait and see what they say on their things and how many people are on there coming back. I would anticipate by the end of the day, we're going to have roughly 65, 70 people to ask to talk to in 1 hour in one room. I think that many people will fit courtroom A.
Yeah.
So, if we just select out a few in the morning, however many, in the morning, one by one, we interview one by one here, and then take them up and do more of a mass court item at that point in time. The only potential with that is we'll have to figure out the seating chart, but we can do that.
Do you, like, in mass as many as 60 in a month, as opposed to trying?
We could. We have more risk of taking a whole pool, and that's it.
That's kind of my.
There's no other. I mean, that's why if we're doing them individually, one by one.
But if you identify the people you had your highest degree of concern about, right? And we do those folks individually, and then we deal with them, however that all shakes out. And then we go start the rest of the folks. We've got 50 left or 55, whatever. Wouldn't it still make sense? There you go. 17. But wouldn't it still make sense to do it like a tranche where you have it manageable, go through those folks, move them out, you get so many jurors, and bring in the next group.
Let's talk about pre-entry. Are we just... I forgot what we did the last time. How many perjuries for the defense claims? I can go pull that out if nobody remembers.
I don't remember which one.
I can't swear to this, but I'll just tell you the number 96 in my head. But I could go back to check it too, but I don't have those.
It's in whatever we submitted the last pretrial order. So I'm going with whatever we agreed on last time.
Okay, well, we'll just have to play it by ear.
There were a couple more questions off of their longer form that they asked us if we would consider for the short form. I don't know if you want to go through those or not.
Well, I think that In my mind, it's an agreed upon jury questionnaire or no questionnaire. So I do think that the agreed upon questionnaire, at least for the cause, needs to have more of the basic stuff in it.
Yeah, no, add their background stuff. I'm fine with that, Judge. I really didn't have it in there because we thought they were getting the regular Pinellas County sheet. So we could go ahead and put their more detailed background information sections. The rest is agreed, and we've got a questionnaire. It's exciting.
All right. I wasn't exactly sure how you were going to go about this. So like I say, we submitted our form. I thought if you were inclined to go with the shorter form, I approached Shane on one of the breaks. And I said, well, if the judge is inclined to go that way, I would nominate, I think I got a list of 7 off of our form that I would suggest be rolled into that if they were amenable. And so I could give you those and we could discuss.
I think that needs to be an agreed upon form. This is one of the issues in the tobacco cases. They generally don't use jury questionnaires. Why? Nobody can agree on them. So I don't want that to be an issue. There's so many issues like this. We don't have the jury questionnaire.
Judge, what we'll do is this. We'll put together, using the background stuff, add that in, we'll number the pages on the agreed. We'll take another look at the 7 they proffered, but one of them is, are you leaning either way in the case, which isn't a basis for cause anyway, unless someone says they can't be fair and impartial. So we don't want that question. We don't think it matters. It's sort of doesn't. So.
And let's talk about one other additional thing. When prior hearings on the eve of the last time we covered some of the stuff we were having the trial, Rearsdorf had suggested that they had number panels for each of the jurors to hold up. So is that
like an auctioneer? Like a little auction battle?
Yes.
I like that.
That you all
It'd be
want
fun.
to utilize. So you're using the number as opposed to somebody's name.
As long as I've got either by, if we know enough ahead of time, right, we're all in the same place about how we're going to seat them up in A, Judge, and we know where one's going to start and whether you're going to go to the next row behind or across. As long as I know where the numbers are, if we do 60, the paddles may help, or the, whatever you call them. What do you call them?
Paddles, I think, number panels.
Number panels, whatever they call them.
Whatever.
Yeah, it may help if you've got 60 in there. If we're doing them 20 or 25 at a time, I really wouldn't need it, but it's okay. Can't hurt.
Okay, so we want to use the number panels. I think we're asking for 500, which we would anticipate 300 people roughly coming, based on some of the other recent percentage rate returns that we've seen.
Yeah, and just to be clear, I don't think this whole idea of going one by one is going to matter. In other words, once we get sort of the group we're really going to question, I just don't know that I'm going to have a choice. I know CRC does it a lot, and I'm going to reach out to some people. It will be time consuming, but I just can't risk the idea, Judge, of getting into some dialogue. And you know how it goes. One thing comes out and we've torched 30 jurors. So.
I understand. But we don't have a backup.
Right. And so we may have to just sit them down, one by one, and so it may not matter so much how they're sitting. So.
That's also why I'm more
I don't think there's a thing that can protect us from somebody popping off something that they read or heard. I mean, whether there's 20 people there or 60, you're going to hurt the whole. It doesn't matter. You lose 20 at a time instead of 60. So, yeah. So, Judge, we'll get the questionnaire worked out. The minimum will be adding their background stuff into the agreed upon for cause. We'll take another look at their 7 and let them know if we're going to add any of those in, and then we'll just.
Just one second.
Yes. Right. When you say yes.
The clerk would need them on the board ahead of time. So
Not a problem.
Okay. All right, great. Okay, so now I think the last thing is the court colloquy. If y'all can on that, and that's mostly like on the statement of the case and some of those things that you want me to announce, not only for the very beginning on the first day when we're doing hardships and as far as anything else.
Statement of the case, your less is more, right? Or no? What's your preference?
I think less is more.
Okay.
Less is better. And we got one from 4.
All right. Okay.
Okay, anything else that we need to talk about?
Just the one question there. Do you want to get the colloquy before you do the hardship
Yes.
or after?
No, I think it has to be before.
You get groupies, you get trial groupies. They'd be here before their hardship. Like, wait, is that trial? Well, yeah, I can make, all of a sudden the true answer on the hardship goes away.
You want people that want to be there, so yes, if you do.
I call trial groupies.
Oh, that's not true. You're saying something else.
Judge, I'll tell you the other thing. I don't know. Didn't you tell me you have a very strong social media instruction these days?
Oh, the one from the Supreme Court.
Can we incorporate maybe language from Judge Moody's Middle District instruction? There was a Middle District case where Judge Moody, I think.
Well, you all will get together and see if you can agree on that instruction. There's a standard instruction that the Supreme Court has given us. It talks about you're not allowed to photograph each other. You're not allowed to photograph people in the courthouse. I mean, that's the standard one that I give every trial. It just recently changed, not too many months ago, maybe last fall it changed to add in you're not allowed to have your cameras or your phones and don't be photographing each other.
I think Judge Moody did an order. He sanctioned the juror. There was some language in that that's been showing up in other trials around the Bay Area. So let me look at it. I'm petrified also of what they do when they leave here. So, sorry.
Just in a simple car accident they do. So.
Oh, I know.
We routinely have police interview the jurors to talk about what all they've now posted on social media during the course of the trial.
Yep.
About the judge, about the lawyers, about the temperature in the courtroom.
Just one last thing. Sorry to return to this, but I do feel like because we got a bunch of new information today on the Mr. Dennis's family's trust document issue, that I'm and once that order is issued, then those subpoenas could go. I just asked you to stay for 7 days so that I can speak to him and see if he wants to do anything about it. Obviously he's not here, so.
That's fine. It'll take them that long to get the order anyway.
That's fine.
Anything else? Okay, thank you all. So the next time we see each other, February 17th. Unless we get some ruling from the second DPA, we need to have some kind of hearing. Maybe we will. Great. All right. Thank you.
Thanks, Judge.
Mr. Ferry, Mr. Boat, do you know something I have it organized that helps you? It's not that way from the... So we know there's no issue.
Okay, just read them again, just a quick turn.
Rachel's not one official.
Yeah, ask her when you go in there. She just asked me.
Yeah, I love it. How long is the whole day? Never issue this little lifesaver, okay? What did you guys do? That's the first time it's done.
Chairman.